Okay, so this was about section 2M, section 21J, section 21M, section 21J, section 21JA. Technical advance or having economic significance, and that makes the invention not obvious to a person skilled in the art. This is the second component. This is the second component in the definition of inventive step under section 21JA. Alright. So now one more thing that is defined, just a minute. One more thing that is defined is new invention. New invention is defined under section 21L. Right? And why is new invention defined? New invention is defined because in section 21J it says just a minute. Section 21L, it says new invention because in the definition of invention itself, it says invention means a new product or process. Okay, so for that reason, this word new has been defined in the word new invention in section 21L. And then what is section 21L? And how do we define newness of any invention? We define newness of any invention by way of ascertaining whether that invention has been made known to the rest of the public before the patent was filed in conceptual terms. Okay, just understand what does it mean, invention. Invention means, okay, forget about statute right now. In general, invention, any one of you will admit that invention means something new for the first time in the world, for the first time in the entire world, not only in your country, for the first time in the entire world. That means an invention. Okay? Right? So in that case, if it is for the first time in the entire world, the entire patent enforcement system revolves around to ascertain this particular phrase is true. Inventions, patents to be granted for only inventions, and those inventions should occur for the first time in the entire world. For only this particular sentence, 85% of the Patents Act has been drafted in every country. 85% of the patent law, because laws are different in every country. So patent law is the correct word here. 85% of any patent law in any given country or any international agreement revolves around this particular consideration that patents must and should be given to only those inventions occurring for the first time in the world. And to ascertain and ensure this particular phrase is true, we needed to draft this much lengthy patent statute. Not only we, the entire world, all the countries. Understood? So therefore, section 21L, in an attempt to define newness of the invention, It says new invention means any invention or technology which has not been anticipated by publication. Which has not been anticipated by publication. Anticipation, the synonym of the word anticipation might be prediction or knowledge. Okay? Guess or derivable, easily derivable. Okay? Deducible, you can deduce. Okay? That means there is a prior existence of hints of your invention. Fine. But exactly to follow the legal system or to follow the statutes, how do you ascertain newness of the invention under section 21L of the Patents Act 1970 in India? Newness of the invention is ascertained through checking whether the subject matter of your invention was published, and just because of that publication, this publication anticipated not only, newness of the invention is not lost if the subject matter of the invention was published elsewhere before you file your patent application. Mere publication will not adversely affect newness of your invention. Mere publication will not affect newness of your invention. That publication should cause anticipation. That is the ground. That is the ground to be fulfilled, to allege that your invention is not new. And further, to follow the statutes, exactly going by the statutes, that publication should not have happened before you filed your complete specification of your patent application. Here the term complete specification comes in. So we will discuss now what is provisional application and what is complete specification, or provisional specification or complete specification. Okay. For your information, patents are filed in two different steps. The first one being provisional application or the provisional specification, and the second one is complete specification. Filing the complete specification, there is a timeline given out within which, that is 12 months from the filing of provisional specification, you can file your complete specification of your patent application. Now section 21L says, if any publication, prior publication, if any prior publication happened before the date of filing your complete specification, and that prior publication anticipates your invention. When I say anticipation, it need not mean that exactly the same nature of experimental results or exactly the same subject matter, identical subject matter disclosed in the publication and in the patent application. Alright, it need not be identical, it may be similar, something relates to, and therefore the word is used anticipation, that you can deduce that much of hints are there in the prior publication before you file your complete specification, before you let the world know about your complete specification, about your invention. Okay, so it is always essential that a patent application during its filing process till the complete specification is filed to maintain utmost secrecy and not to disclose to anyone that a patent application has been filed and it is awaiting filing of complete specification. Okay, so just I am reading out section 21L. I may try to make you understand what is the meaning of new invention that is defined in section 21L. To understand section 21L, you need to remember publication, anticipation of publication, or by way of prior use. See, You may know something by reading something, or if you are using something, if anybody else is using the same thing. Okay, suppose I have made a wonderful summer drink, cooling and refreshing drink using some herbs. Okay, and I made a huge banner what herbs I have included in my stall, and I am selling it in the market. Right? Then what is happening? There is no prior publication. It is not officially published anywhere in any journal or anywhere in any magazine. But it is still under use by me only, and people are coming to know about it. People are also coming to know about it because they are getting attracted to my stall, seeing the ingredients that I have mentioned in my banner, in my poster. So I am disclosing my invention to everyone by way of my prior use. Okay, so I am disclosing it by way of my prior use, and people have come to know about my composition, by my unique composition. Then if I go to file my patent application after using it, then the patent office, if the patent office comes to know or have some evidence through some CCTV cameras installed in the marketplace, just assume this guy has filed a composition for a patent for a composition, but he has used it before he filed the patent application in the market. Sorry, you will not be granted a patent. Okay, so there are two grounds of anticipation. Anticipation can be caused by way of prior publication. Anticipation can be caused by way of prior use anywhere in the country or anywhere in the entire world. Okay, but when the publication or when the prior use must have been occurred, it must have occurred before the date of filing complete specification of your invention. And if it has happened before the date of filing complete specification of your invention, then your invention loses the criteria of being called as new invention. And if your invention is not a new invention, it does not satisfy section 2J, because the invention means a new product or process, and just because you don't satisfy new, so you have to leave it there, and your patent goes into the drain. Your patent application goes to the drain. Okay, so before you file what is the practical outcome of it? Before you file the patent application, make sure you have not discussed about it publicly. You have not published it in any journal, or you have not unnecessarily talked about it in any other technical forums. Alright, so this is what I have tried to explain. The connection between each sections. To section 2M, patent says patent. Patent means a patent for any invention granted under this act. The invention is given in section 21J. Section 21J, invention means a new product or process. This new is given in section 2L. And section 21JA, where I define invention, there invention means a new product or process having an inventive step, involving an inventive step. Then that inventive step is then defined in section 21JA. Okay, this is the connection between words and every different subsections under the definitions of patents. Fine. So this slide I have explained before. There are two scenarios here. In one scenario, the inventor goes and discloses about his invention before filing the complete specification in a technical forum. Okay, and that is on 1st January 2020. The provisional application was filed on 2nd February 2020. There was an initial disclosure by the inventor himself to a person in US about the invention, and the person to whom it was disclosed, that US guy goes and works more on my hypothesis or the idea or the technical subject that I have disclosed to him. He works by himself without referring to me. He has every right to work by himself. He is not doing anything wrong. And then he gets it published. He has not done any wrong at all. The wrong has been done by you, because he publishes it before you. You might be thinking, oh, I have got 12 months to file my complete specification. I'll file it. Let me do some more experiments, some more experiments. I'll make the invention more better. Then I'll file a complete specification. Unfortunately, by the time, that is on 31st December 2020, when you file your complete specification, you never knew that that US guy has already published your subject matter because of your disclosure to him. It is not the mistake of US guy, it is the mistake of yours that you have disclosed it to him in between, and he published it before the date of your filing your complete specification. Okay, and by that way you are losing anticipation, you are losing the newness of your invention, of that provisional application that you have filed, because Access publication dated 5th May 2020 anticipates your patent application, of which complete specification was filed on 31st December 2020. Okay, now in another scenario, what you do, you have disclosed to the same US guy after your provisional application, but you made sure that in the provisional application you have given all the necessary and technical details and experimentation figures, graphs and inference and discussions, whatever is relevant you feel. You have given everything in your provisional application and then filed the complete specification. Okay, now subsequently when that US guy goes and publishes his opinion or his findings to affirm your findings or to validate your findings, in that case such a publication will not anticipate your patent application, because your patent application was filed in detail and every aspect of the publication of Mr. X was already filed before the Patent Office of India, before the publication of Mr. X dated 5th May 2020. So here Access publication does not anticipate my patent. Fine. So right now, having said this, having completed the legal definition of patents, let us go to the patenting procedure timelines and the details of provisional and complete specification. Okay, so first, as I said, first you file the provisional application, and within 12 months of filing the provisional application you have to file your complete specification. That is the legal deadline. Fine. Having known that provisional, complete and complete specification, having said that the patent applications need to be made in two separate, not necessarily, but you have the opportunity to make your patent application in two different phases, by way of filing first the provisional specification and then by way of filing the complete specification. Okay, so in that case what you need to know, and it is very apparent for us to have the question, how do we differ in the contents of provisional patent application and the complete specification. Okay, what should be there in the provisional patent application, what should not be there in the provisional patent application, and what should be there in the complete specification. All right, fine. To begin with, in your provisional patent application, you should start with the introduction to your technical field. You should start with the introduction to your technical field. Okay, you discuss what from, it is up to you, and you are the best person to assess from where do we start. And yes, one thing is very important. See, publications are generally written in a manner that any one of your equivalent peers having the same technical caliber or having advanced knowledge of the same field of science and technology they can read and understand it directly. Fine. Publications, the audiences meant for public technical publications are those who come from the same technical background, having advanced degrees or having advanced educational qualifications in the same field of science and technology. For example, if you are a PhD or if you are a research scholar, you will write your publication in the manner so that anyone other research scholars or at least having MSc in this particular field or MTech in that particular field or other PhD holders in that particular field can read and understand that technical journal, that publication, whatever you have drafted, your publication manuscript. But patents are not written only for those people. You should write the patent in the nature such that any person, for example, if the earlier in case of technical journal publications, if the threshold was anyone passing MSc in the same field of science and technology, for patents you should consider any person who is pursuing science in their higher secondary level should be able to read and understand your patent description. That's how you need to bring down the threshold of the audience, the eligibility criteria of the audience to understand what you have invented. Because you have not invented for only the scientific people. All inventions are done for the common people at large. Okay, so it is not required that you start with A, B, C, D and all. Okay, no, common people. Okay, there are so many illiterate persons as well. So it is not that you have to start with so much basic level that school going children needs to read and understand. No, but at least people who has exposure to science education, which happens specifically, at least according to our current education system, after class 10, from class 11 and 12. Okay, they should at least read and understand your invention directly, and therefore for that purpose you understand, you assess from where should I start introducing the subject matter, what should I write in the introduction. At the same time, it does not mean that you start writing very basic applications of very basic theories of science. Okay, not necessarily. It is a balance that you need to attain through your own expertise. So understand, I am not disclosing anything about the invention at first. First I am just doing the introduction of the related science and field of science and technology. Okay, and then you say what do you want to do, what is the idea you have, in very vague terms. You need not focus upon the core technical subject to disclose the idea. You may say what is the outcome of the idea that you are contemplating to mention in your patent application, the outcome of the idea. Okay, fine. Now what would be the end result of the idea, if and only if your invention is successful? What would be the end result? Okay, and that is how the public at large are gonna be benefited because of your scientific and technical contributions. Okay, for example, today we are attending this webinar and it is happening through innumerable technologies which has been patented. Contributions by so many people from different corners of the world at different time phases in different phases of time has individually contributed one of the under component for which this webinar is getting possible to be comments between you and me sitting at different corners of our country. Fine. So in that case, while each and every patent is being written, they will first write in the provisional application what will be the outcome. Okay, what will be the outcome? So that is what I am relating to the idea. Without going to the details of the idea, disclose the idea, and for which idea you need to include what has other people already done to establish that idea. Okay, what has other people already done to come nearby to what you are thinking, or maybe there has nothing thought, but still the basis, the starting point of some disclosure you have to include in your patent application, in the provisional patent application, because inventions are always given on the basis of what? Existing knowledge. Inventions are always given in the basis of existing knowledge, right? Compared to existing knowledge. Which section says that? Anyone in the chat box? Compared to existing knowledge. In the chat box, please type. In which section it was there? No one chatting. Compared to sorry?
Existing knowledge, technically advanced 2JA.
Correct. Not 2JA, 21JA.
21JA.
Okay. So patents are given if the patent has an inventive step, and to have an inventive step, your patent application must involve a technical advance compared to the existing knowledge. So therefore, in your patent application, you need to say what is the existing knowledge according to you, which is nothing but that existing knowledge is nothing but prior arts. And what does it mean, prior arts? Prior arts means prior technical publications in relation to your idea, in relation to your technical idea. Okay, and then after disclosing the prior arts, you should then identify what are the problems in those prior arts. Okay, you should then identify what are the problems in your prior arts, and from those prior arts you have to go a step ahead of the prior arts. That's how you will be able to establish or claim that my invention is having a technical advancement as compared to the existing knowledge. Until and unless you are better than the existing knowledge, how can you say that your invention has got technical advancement? The Patents Act 1970 does not ever say what is the acceptable quantum of technical advancement. It says only that technical advancement should be there. That means even if it is one step ahead of the existing knowledge, then also your patent is eligible for patent protection or getting a patent granted. Okay, so therefore, to establish technical advancement, you should say or identify the problems. You should say or identify the problems in the prior arts, and that's how you establish objectively establish and satisfy the various sections, that is section 2M, section 21J and section 21JA and section 2L of the Patents Act 1970. For those reasons, you have to incorporate and build the story around the invention. So still now we have introduced the scientific knowledge, given the idea and referred to some existing prior arts, and from those prior arts we have identified some current existing problems, and from those problems we propose solutions. What can be the possible solutions? Okay, so you may say that it is possible, you may contemplate that those problems can be solved from by this way, that way, or three different other ways. Okay, but please keep it in your mind that never ever say that you have to you have to do the experiments, or like the phrase that I just mentioned, can be solved, may be solved. No, you have to say diplomatically that the solution is possible by way of doing the thing like this, like that, like this, like that, which does not necessarily mean that you have already done the solutions, but the proposals are still valid and has been done in the past tense. Okay, so those proposals, suppose here in this screen you can see 6 different screens. I just meant that these are the possible solutions to that particular problems, to those particular problems, or maybe there may be 6 different problems to which you are proposing the solutions to these 6 different problems which you have derived from the prior arts. Okay, and then to establish a proposal you also show some nominal experiments. I am telling nominal experiments, not full experiments. If you give full experiments, it becomes a complete specification. In the provisional patent application, you have to just give nominal experiments, which gives an indication that your proposals are working. The proposal that you have gave are working. Okay, they are not contradicted. And while you present your proposal and the problems, the point to remember is you have to present everything in past tense. Do not write ever that you will be doing the experiments the way you are proposing. In that case, if you have to do the experiments, then why are you filing the patent? You have not at all invented at all. You have not at all invented as of now. Then what legal ground do you have to file a patent application? In most of the patent drafting exercises, people do this mistake, even when they are being asked to draft a patent application in practical terms. And the same mistake is also committed by the candidates in the patent agent exam. If the question asks for provisional patent application, they will say everything is possible, this is possible, that is possible, that needs to be done. And exactly this is replicated in complete specification also, which is also a bigger mistake, because all the technical people, the scientific research scholars who take this exam, they have an habit of feature the way forward in their publications. Am I correct, Dr. Basu?
Yes.
Correct. And the same thing they write in the patent application, in the patent agent exam, like that. Okay, so for that reason, they lose the entire marks in the paper. This is 100 marks, and 100 each of the individual marks in 100 marks are objective in nature. Please remember, it appears to be subjective, but the good point, the interesting thing about it is, I feel each and every 100 individual marks are objective in nature.
While writing them, I have one question.
Yeah,
While writing
please.
the paper, the length is not important. Only the points are important, I think.
What is not important?
In the answer, in the exam.
Hmm.
Though these are descriptive questions,
Hmm.
subjective,
Hmm.
the length is not important. Only the points are important.
Correct. Exactly. The length is not important. Your answer should contain all
Detailing
these
is important.
aspects that I have said here.
Yeah.
Okay, if your answer contains all these aspects, the examiner will try to find out where should I deduct the mark. Okay,
Okay. Okay.
and those 100 marks, there is no syllabus for those 100 marks. It is just mere common sense. Just mere common sense, nothing more than that. Only if and only if you know this, whatever I am disclosing now. And yes, there is a particular format of drafting a pattern specification which I will take in subsequent classes. All these particular points goes into different format, different headings under the patent application drafting process. Introduction goes under the heading of background of the invention. Okay. Similarly, prior arts goes under the heading, prior arts and the problems goes under the heading of background of the invention. Then from the prior arts, after the background of the invention, you give objectives of the invention, which comes from the problems that you defined in the prior arts. What are the objects of your invention? The objects of your invention is to solve the problems that you have defined. So from the prior arts, if you have identified 3 objective problems, then your object of the invention is to solve each and every problem. So to write the patent is very easy. Just to write a statement, the objective of the invention is to solve problem number 1. The objective of another objective of the invention is to solve problem number 2. One more objective of the invention is to solve problem number 3. Simple. And then after you have given the objects of the invention, you start to detail brief description of the invention, where you disclose the idea and your logical experiments. What I am going to teach in subsequent classes about patent drafting, I have already said right now. And you can go back to this to my YouTube video and refer to this discussion if you are not having the access to the subsequent classes. So gist also I have mentioned here. Fine. Now when you have filed a provisional application, your timeline starts, your time starts ticking. You have to run and ensure that within 12 months you file your complete specification. Okay. Now coming to complete specification. Now it is very important to differentiate your provisional application in your complete specification. Okay, as I told, in provisional application you have disclosed so many proposals. Okay, now after 12 months or after 10 or 11 months, you know for sure which are the proposals which are working, which is worth working on. All right, so you now take only this particular proposal, and then you go ahead in your complete specification. Or you may take only this and this particular proposal, and then you go ahead in your complete specification drafting, because you are now convinced that this and this proposal actually works to give the solutions to the problems that I have cited. Okay, so what that means, you define clear line about the scope of your invention. Your invention includes what and it does not include what. Don't worry, in your provisional application, if you have cited so many proposals, nobody is going to come and ask you, oh, you have said this, you have said that, then why didn't you say in your complete establish in your complete specification? No one is going to ask you that. No one is going to ask you ever. And you are not liable to give any explanation also, anywhere in the world, in any judicial forum. Okay, because only the complete specification is going to be published. Provisional patent application are never published. complete patent specifications are going to be published. So complete specification, when they are going to be published, in that complete specification, because it is going to be published, you should be very careful about the scope and extent of your invention. So you first define what is your exact scope and extent of the invention in your complete specification in very, as much as possible, objective terms. Okay, because this drawing the line also will define your claims. This drawing the line will also help you establish the inventive step of your invention. Okay, because as I said, anticipation by prior publication under section 21L, it happens, there is a publication and that publication should anticipate your invention. Okay, that publication should anticipate your invention. That is the ground, right? In section 21L, there should be a publication and that publication should anticipate your invention by way of publication before your filing complete specification. Okay, now for example, if there is a publication already, which apparently appears to be similar to your complete specification or your field or your subject matter of the invention. Okay, but in your complete patent specification, what you will do, you will draw clear lines, you will make proper statements in your invention, in your patent drafting exercise, as to what is excluded and what is included, what is specifically included. Now if that specific inclusion is absent in that publication, prior publication, then automatically that publication does not anticipate your invention, because that particular specific inclusion is there only in your patent. Got me?
I have one query.
Yeah, please.
In a patent application, why there is this provision of two specific or provisional and complete? Why not only one? Because if I have invented something, then I know it totally. Then I can write it at once. Why first provisional, then complete one? What is that? What is the?
This is the legal opportunity given to you. If there was no
proof.
With proof, yes. That is just an opportunity that you make a claim, then you go, then to whom you make a claim, they will say, what is the basis of your claim? Go and get that basis. For that you are being given time. Okay, so for that reason, anything, sir, any particular, actually, this question relates to the entire legal administration system, judiciary system in our country.
Yes.
Okay,
yes.
First you file a suit. Okay, you make some allegations or you make some statements for your protection, alleging somebody doing something wrong.
Yes.
When you file that suit, the court or the judiciary will not ask you to submit your evidence directly. Okay, generally if you file that suit that is called as plaints, filing plaints, then the same plaint is being defended by the opposite party. The opposite party is being given an opportunity to file his written statement. It is called written statement legally, saying that in the written statement, the defendant is being given the opportunity to make counter allegations. Okay, because court does not know, कानून अंधा है. You might say allege anything without ground. So first you make allegations on paper, you make counter allegations on paper. Once the allegations and counter allegations are done, then the court will go for the evidences. Submit your evidence in support of your allegations separately. This is the basic process of any judicial administration system. Okay, yeah, justice delivery system. So same way here in provisional application, you first disclose or claim, allege what you have invented in your favor, and then you come with your proofs within a period of 12 months. This question will not come, this is only for your understanding.
Yes.
Okay, it will never come such kind of a question. Why there is a two-way method of filing the patent, two opportunities given to
Two
file a patent
steps, yeah, two
application.
steps, yeah, two
Okay,
steps.
but understand it like that. It is better for you. If there was three opportunities, I would have also been overwhelmed. If you commit in the second opportunity, you correct yourself in the third opportunity. Okay, the more the number of opportunities you get, the better is your stance to claim what you deserve. Correct?
Yes.
Okay, so in the company specification, you have to draw particular specific lines, that is define the extent and scope of your invention, and then after you have defined the scope of your invention, you start giving your experiments. What exactly have you done? How have you done? Where from did you get the raw materials? Because these all relates to enablement of your invention. Yesterday I said enablement of your invention.
Yes.
Correct?
Yes.
Making the secret open. For whom? Why do you need to say all those? Who can explain?
What is the question?
Why do you need to give all those things? Raw materials and sources and experiments in chronology. What is the requirement
Because
of
ultimately, it has to be applied
it has to
by
be?
someone for society. It can be so that it can be applied for society again by someone, by whoever takes the opportunity to again either
Yes.
take the license and they use it for the public
No,
or
forget about license.
general.
Your bottom
For
line
the
is
education,
correct. Bottom line is
for the,
correct.
so
But
that one can repeat it exactly.
exactly for anyone to reproduce your invention once
Yes,
the term of your patent is over.
yes, yes, yes.
License is again at my option, right? You have to take permission
Yeah,
from me.
at my disposal. Okay,
Yes.
but after the
But
period
this
also,
enablement is not for you. This enablement is all the public at large except you.
yeah,
And that is why you should give this in your company specification. Okay, and this is also an eligible ground to pull back a patent application, to oppose a patent application. We'll see patent oppositions in due course. Okay, you can say that the patent might be having novelty, inventive step and utility, but I'm sorry, the patent does not say how do I practice the invention. So if even that is
yeah.
not there, then the patent office may reject your patent application.
Another way is that due to patent, the public or society is not getting the product at an affordable price, at a much higher price. Then also it can be challenged.
That is these are
I
all
got somewhere.
yeah, you are referring to compulsory license, but
Yeah.
this is also one more reason why good. This is also one more reason that you should provide enablement of your invention.
Yes.
Okay, and this forms the basis of the social contract that I mentioned yesterday.
Yes. Yes.
You are giving to the government.
Society.
You are giving to the government
Comment for
for the society.
Yeah.
And that is why the government is under obligation to publish your patent, because the government works for the society at large. So you're giving your thing to the government, and therefore government is under obligation to publish the patent, and therefore the patent is automatically published. And therefore, as an academician, I urge specifically you, Dr. Basu, to propagate the knowledge that go for patent publications rather than going behind journal houses to please publish my work.
Okay.
Nobody is going to review, no peer review, nobody is going to judge what you have done. It is completely up to you. You can automatically get a publication in your favor. And
Yes,
the
yes,
impact
yes.
factor, equivalence
Will
of
be very
the
high.
impact factor that you get through a patent specification is no less than the highest impact factor accepted in any
Yes.
technical forum.
You're right.
Okay, if you
So we should
say
go
to
the other way.
someone, I have a patent publication, they will definitely, irrespective what is there in the patent publication, that might be bullshit.
Yeah, already it is verified. So they will just publish it.
No, it is not verified. It is not verified. A patent
No,
publication,
when the patent is there, so it is already verified by the authorities.
it is not verified at all. Please understand, it is not verified at all.
Okay. Okay.
You just copy and paste a Bollywood movie in your patent application and file it. It will be published. Bollywood song, हमें तुमसे प्यार कितना कि हम नहीं जानते. Just write it and file it in the patent PDF and file it. It will be published in the patent journal. No verification at all. But still you will have a patent application number. You just write the topic properly in the scientific terms, the title properly in the scientific terms. People will say, oh my god, what sophisticated technology you must have done. Okay, you should not do that. But yes, I have seen smart people doing like that. They are disclosing science and technology. They are writing mere theories of science and technology, not applications of science and technology. And still, the favor they are being accorded is having patents published by themselves. Unless only a granted patent is reviewed, patent publication as such, what is filed is never reviewed. Okay, understood? Once the government is just following its duty, you are filing a patent, so the government's duty is to publish the patent, and it will automatically publish without taking any money from you. They will just take the filing fees. Got it?
Yes, yes.
Okay. Now, after raw materials and science resources, the next thing is, in your experiments, you have to provide comparative experiments. That means you have to undergo the same process what is suggested by the prior arts that you have quoted, and then you have to undergo the experiments of what you have suggested in accordance to your idea, and then compare and establish that the outcome of your invention, the outcome of your process is better than the prior arts.
Yes.
And that is why there is a technical advance in comparison to the existing knowledge. Is it difficult to remember the sections now? Is it difficult to remember the sections now? Please tell, all of you who are attending.
No.
Do you understand why the sections contain the language that is included there? Okay. And then after saying that your invention is better, you say what are the advantages that you have got through your invention. Okay. And followed by your invention in your company specification should also be supported by exact scientific evidences, that is through figures and graphs, whatever applicable. And at the last, the must and should component of a complete patent specification is the claims. The claims sets up a legal boundary which prohibits others to enter into your invention without your permission. If there is no claims, then the patent application is incomplete. Okay, please understand these things very, very carefully. there may be questions like uh, your client gave you the patent application and he wants to file a complete specification. He gave you the idea, he also gave you the technical details, okay, and he also shared with you the uh, provisional patent specification that he had filed himself. Now what will you do? Now what will you do to uh, now what will you do to take forward his patent application? So there you should say that you have to file the complete specification, and that complete specification as a whole should contain all those particular things. It should define the scope, particular scope and extent. You should make that patent application specific to one particular area of application. You should give experiments in chronology. If required, you will ask for further set of experiments to do comparative experimentation between prior arts and your invention. Thereafter, at the last, you will draft the claims. Claims must be incorporated, and then file the complete specification within 12 months of the of filing the provisional patent application. You just have to
for only one invention.
For only one invention. I'm not going to those things right now. Let go one after another. Okay. So when the question was asked, that question did not wanted you to draft the claims for him as an answer to that question. The answer to that question lies in the proposed solution that you will offer to your client. Okay, and there you may say that the provisional patent application lacked the claims, so I will write the claims, I will draft the claims in accordance with the established practices of patent drafting, and in accordance with under section 10 of the Patents Act. I may draft the claims properly drafted claims having clarity and conciseness, and in a manner not indefinite to understand. For example, you cannot include in your claims a composition having high concentration of XYZ salt. High is a very indefinite term. What high? Whatever is high for you may be low for somebody. It is subjective term. So the claims should not contain any subjective terms at all in the entire set of claims. We will go to the claim drafting part later. But you have to say like that in your invention that those things were missing in the provisional specification filed by the inventor. So I will modify that provisional specification and make it better, the drafting part, with respect to specified scope and extent, giving the experiments, graphs, proofs of the invention, and then followed by the claims. I will draft the claims and file in the complete specification within the stipulated allowable time. Alright? Okay.
Yes.
So now, patentability criteria. This is something which I have actually discussed with all of you before in other occasions, in my other webinars. All the participants must have attended my one or the other webinars with different colleges, so I would skip. So I will just revise what did we learn today. We learned again the legal definition of patents, and then we learned about provisional and complete patent specifications. We also learned about patent eligibility criteria already. Now, how to understand how to actually determine new invention, how to determine not anticipation by prior publication. This is what is given in patent eligibility criteria. So section 2L actually says refers to novelty of your invention. New invention means, as I have said already, novelty is given in section 2L and section 21J and section 2, not section 2L, section 21L and section 21J and section 21JA. It says about what? Anyone? It says about what?
Inventive step.
Correct. Don't feel, I mean, even if you are answering something wrong, answer with the utmost confidence in your mind, within yourself. People, you will get marks for the confidence that you have shown. You said it correct. Inventive step. Okay. And utility. Where is it given? Utility. Which section?
21J.
Huh?
21J.
21J? Yes. 21J. Capable of industrial production. And one more thing is enablement, which most of the people would miss. Dr. Samba, we are having discussion, some disturbances from you.
Yeah.
You want to speak something? You can speak.
No. Just a 2-1 just I want to say. Anyhow, don't.
Okay. Okay, and the next thing is enablement. So this is what is often overlooked. As I said, enablement is often overlooked in a patent application, in the process of drafting patent specifications. We'll see later. Now these slides I'm just and this is not the part of patent agent exam, so I'm just going forward. I believe all of you must have seen them. It's just I have refined it properly. Novelty and inventive step. Later on, if you want to understand this, later on you can come back to me and ask me. After this, we will just go to the procedural aspects. Not too much, oh my god. Okay. Procedural aspects about patent publication and examination. Only till this much, if you know, only till whatever I am going to discuss right now, only till this much if you know, I am sure with this knowledge and the knowledge of patent drafting, I am sure that you may still get more than 50 marks in the patent agent exam. Only if whatever I have discussed till now, plus this patent publication and examination process, which is yet to be discussed. So I would like to take an opinion. Do you want to do it now or tomorrow morning?
Tomorrow morning.
Tomorrow morning. Okay. I'll ask Rocky, would you like to speak up? Mr. Rocky? Please don't hesitate to speak up. Okay, Rocky says his microphone is not working. Anyways, Rocky says his microphone is not working. It's okay, fine. Please respond. If possible, answer the question requesting. What question did you? I have a question, dear RDG. Whether publication prior to patent filing can provide me protection under section 31. Rocky, you have to elaborate your question. I have not seen your questions till now. Publication prior to patent filing can provide me protection under section 31. I did not get your question. Anyways, you can call me up anytime. I gave you my number yesterday. I'm not dragging this session as of now. I'll try to answer your question tomorrow definitely if you please join again. Fine. So concluding this session here. Thank you. Good night and study well. It is chutti for me, not chutti for you. Okay? For the next 1 hour at least. Yeah, please say, Dr. Basu. Dr. Samba, please mute yourself unless you want to speak something. Please be known, Mr. Rocky, that publication can never ever give prior publication before you file your patent application will never make your patent eligible to be granted. You will get no protection at all if you have published under any particular section. Publication means disclosure of your invention before you have actually filed your patent application. So how will you get protection? So as such, the straight cut answer to your question is no. Okay, and yesterday Rajeshri asked a similar question. That if she publishes her subject matter of the invention in any of the journals, and then within 1 year if she files her patent application, then if the publication was done within 1 year period of publication in any technical journal, then can that patent be granted? The answer is yes. Although it will cause anticipation under section 21L, but still there are other applicable sections in the Patents Act which allows you to protect a patent application if you have filed that patent application within 1 year of the initial publication, either by yourself or by any third parties. Okay? Fine then. So right now I am concluding here. Thanks for joining and thanks for being with me for this much late hours at night. Hopefully we join tomorrow again in the morning at not 6 o'clock in the morning, 6:30 in the morning. Okay? That's from 6:30. Fine?
Okay, good night.
Okay. Good night.